All right, Mr. Steven, it looks like we are live. So it's been
Yes,
like
we are.
6 months since we did this. So it's good to see you again.
Well, I know you were super busy last time around, and plus it was a 5 week month last month. That kind of threw things off. But yeah, we are live here with Legal Ease, broadcasting worldwide, globally on your YouTube and my Facebook and everything in between, man. I'm just excited to be here with you, man. We're gonna be finally meeting each other in person at CreditCon coming up, aren't we?
That's right. That's right. So that'll be in the Tampa area, I guess, Sunday, June the 6th, right? Through
Yeah,
Wednesday, the whatever that is, the 9th.
exactly. Yeah, June 6th at the evening is kind of their intro cocktail party. June 7th through 9th, Monday through Wednesday is the actual event. We'll be there. I'll have a booth. We're launching our brand new pre-litigation disputes Palmieri system software there, John, that you've been asking so much about it. And man, it's just super exciting stuff. But really looking forward to meeting you. And for those guys who are watching this, you can go to credit-con.com and get more information on that. And if you're wanting to go, use the promo code PRELIT100, PRELIT 100, and Matt Listro, who is the Credit Con founder, will give you $100 off if you want to meet John and myself there live. Literally, the hotel's like right on the beach, so it's gonna be good times. So, well, talk
Yeah.
to us, John. Give us some good news, man.
Yeah. Well, that will be good. There'll be a bunch of people there, studying and learning and meeting each other, talking about how to fix credit report errors. So that's always a good time.
It
And
is good stuff, man. Good
there'll
stuff.
be some good folks there. And let's see, what'd you say that promo code is? I'll put it in the comments.
Prelit, PRELIT 100, 100. Yep, credit-con.com and prelit 100 is the code. $100 off your ticket. Now, I think all of their blocked hotel rooms at the reasonable price have been sold out, but there are other hotels, within a nice little Uber ride around where you can get still pretty good rates and stuff. So, but what's happening new in the consumer protection litigation world, John? Talk.
Just we're suing some bad guys, and I always enjoy that, and having some trials, and so it's been good. I tell you, Stephen, one thing we did, and by the way, from my end, I'm not sure, is this going live in the
It is,
the
yeah. I've got the
litigation?
Facebook. Yeah, we're up in. I've got the Facebook pulled up. We're live in there. So
Okay. For some reason, when I did that comment, it doesn't look like it posted, at least on my end, but hopefully it did.
yeah,
Actually,
yeah.
in the
We
group.
are
But
live. By the way, for those of you who watched us live, comment below in whatever thread you're doing it, and that's why we're here, man. So ask us your questions, anything related to suing the bad guys. Which, by the way, John, do you ever go up to the bench and talk to the judge, and you're like, "Well, judge, this is very simple. This case, I'm just trying to sue some bad guys," and then the defense attorney is like, "Well, Your Honor, we kind of feel as if we're just being sued by a bad guy because we gave him the money and he didn't pay us back." So isn't it funny how that works out? The perspective is
yeah,
everything, isn't it?
we like to make it simple, that
That's right.
let
That's right.
other people complicate it. We're
We're
like,
not we're not saying that you didn't give the consumer the money and that he didn't pay you back, but we're saying you violated this little statutory law, so the penalties are more than he defaulted on. And so we're going to go ahead and reverse this thing out here.
that's right. That's
That's
right.
pretty much how
So,
you roll. Let's see.
but yeah, if you guys will put any questions that you have, and we will be happy to discuss those. And both of us have about an hour to about 5 o'clock Central. We'll need to wrap this up, and let's see. Let's see what we've got.
Lashana is watching us live. She had posted up from Facebook.
Okay.
Yeah, she's a super fan. She's in our training course. Which, by the way, did you want to start with that little truth in lending thing that we were talking about before? Did you
Oh
want to?
yeah, yeah.
You
Why
want
don't
to?
we do that, Steve?
Yeah.
Uh,
So, guys, I'm going to do a quick share screen. So we've got one of our super fans here, Miles Magyar. He posted up and sent me a question actually regarding some credit reporting. So let me do a little screen share if I can figure this thing out. Let's see. Select the screen. There we go. Let's do this. Okay, so I think, boom. So Miles kind of sent this over. So, do installment loans, auto loans have the same rights as mortgages under the FCRA and I think he also meant Truth in Lending Act because he cites it down here. So kind of the scenario is an auto payment was made in August of 2017, which was enough to actually cover the principal plus interest. However, there were late fees. Okay, so the payment was made to cover the normal payment, but not the late fees, and so can be marked as late. So the lender takes the full payment and uses it to pay fees and charges, and then applies the remainder to. So let's just say, well, let's say we've got the credit report here. So well, the monthly payment is zeroed out. So let's just say it was a $250 scheduled payment, which includes principal and interest. And let's say there's $50 in penalties for whatever, maybe they made their last payment late and they charge $50, whatever. So you've got a $250 payment owed and $50 in penalty. So you mail them $250 instead of $300. So what they did was they took the $250 and they applied the first $50 to pay off the fees, and then so there's only $200 of your payment remaining, which is applied to the regular payment, but now there's still $50 of that regular payment because you didn't mail them $300 instead of $250. Is that legit? So I think a couple parts to the answer. So number one is, and here's the credit report, which we can look at, but number one, I think it kind of comes down to the contract. So I mean, if the contract says, hey, we will apply your payment in the following order. If you have late fees and all that kind of stuff, we're going to apply your payment to that before principal and interest. I believe if that's spelled out in the contract, then it's totally legit. We'll let John chime in here in a second. But then Miles kind of cited this part of the Truth in Lending Act, which has to do with mortgages. So, he was like, hey, does this apply? I don't think it does. He was like, and you're right, it wouldn't. But let's kind of pull that up. See if I can find this over here. Okay, yeah, here. So basically, there's this little section of the Truth in Lending Act, which has to do with the secured dwelling, but basically it kind of has to do with servicing, and it's a violation if they don't credit a payment to the consumer's account the day that they receive it, basically. So, but this is, as you had pointed out, kind of in your question, you kind of already answered yourself when you had sent this to me, Miles. That doesn't really apply to auto loans. So, if you look down here at the payment. So it went delinquent in April. Let's see up here. You said the payment was made in August. Okay, yeah. So looks like this payment was made in August, and then in September it went 60 days late, which I guess is probably because there was $50 remaining. And then I guess he just continued to roll 30 days, but now it's really 60 days roll because there was a $50. And then I guess in November, December, he figured it all out and was able to catch up. So I mean, just on the face of it, as far as that specific fact pattern, I don't think there's anything wrong with that. I mean, if you want to further analyze the credit report, they don't give us any of the historical information as far as the actual amounts paid each of these months, the actual payments that were due each of these months, and I mean, so it's not a complete credit report disclosure if we're going to look at how these things should report. So there's definitely some errors and some issues with that. But that particular fact pattern, I don't see any problems with myself. So, John, take it away, sir. What are your thoughts on that?
Yeah, so with mortgages, they tend to have to apply it directly to the principal and interest first. And almost every mortgage contract says that. So the key here would be, what does the auto loan contract say? It may say nothing, but it may say, when we get a payment, first we go principal, interest, late fees, charges. And if you can find that they violated the contract, then that would be false credit reporting, because we really weren't late, because we made a full payment in August 2017. And so that's going to be the key, is to get that contract, take a look at it. And also under state law, there could be something, I don't know where the consumer is, but there could be something in state law that says, hey, a car loan has to be applied in this manner when you get a payment. So something to look at. And it's, I definitely appreciate his diligence in looking at that, and trying to be creative and say, hey, this just doesn't look right. And if it doesn't look right, there's a chance that it's wrong. And so you investigate it. So, definitely good thinking with that.
If it's reported on a credit report, there's a good chance it's wrong, right? That's the starting point of philosophy. So when you do, Miles, under the UCC, the Uniform Commercial Code, you can send a written request to them to request like a statement of account records and stuff. They're supposed to send it out to you within 14 days. So, I mean, you can request documents from the auto lender under the UCC, as well as obviously, you could certainly send them just a direct correspondence, even a furniture direct dispute under the FCRA and ask them for original records. They're not necessarily required under the FCRA to provide them, but there's a decent, well, I wouldn't even say there's a decent chance they will, but maybe they can. But under the UCC, you can send those to them, and they're supposed to respond. In that case, they're supposed to send you a statement of your account. So, yeah, let's see if we can get that contract, take a look at that, and then update us, Miles, and we'll kind of go from there. So I appreciate you asking us about that. So,
Yeah, that's an interesting one, Miles. So let's see.
All right, looks like we've got some comments popping in here, huh, John?
Yeah, so we got the legendary Stephanie Adams here. So,
Super
hey,
fan,
fellas.
Stephanie.
Yeah,
Yes,
good to see you. And Stephanie,
which, by the
if you
way, wait,
want,
hold on a second here, but I've got to say, why is Stephanie watching from your YouTube and giving you the traffic and not watching from my Facebook group, Stephanie? And I even took a phone call earlier today, man. Come on, what's up? You're giving him the traffic, not me. Oh, man.
well, she is rocking and rolling on YouTube. So, that's good. That's good. She's got some good videos on there about,
Yes, indeed.
credit report. And Stephanie, if you're still with us, drop a link in to your channel so we could share that, because you have some very good videos there. Let's see. Yeah, Antonio Maddox. I have answered my lawsuit at the courthouse that was filed against me, but I haven't heard from them in 2 months. So, Antonio, what I would do is just call the court and just say, hey, is anything happening? They may say nothing's happening. I don't know what state you're in, but they may say, oh, you have a trial date in 3 weeks, or you have a hearing coming up. So you don't want too much time to go by. If you're doing this on your own without a lawyer, don't let too much time go by without checking in with the court to see. You just want to make sure you're not missing anything. So that would be my suggestion for you.
It'd be interesting, John, because FCRA, they're a publicly traded company, aren't they?
Which company?
PRA, Portfolio Recovery.
Yeah, Portfolio.
Some of these big debt collectors. It'd be interesting. I don't know. I mean, because their financials are obviously public because they've got to file with the Securities and Exchange Commission. It'd be interesting to see if we could figure out how much they spend on legal costs and stuff. Wouldn't that be kind of interesting to literally find out? I mean, some crazy ass amount.
Yeah. You can find all sorts of stuff. I remember maybe 5 or 10 years ago, we were suing Portfolio for using auto dialers, violating the TCPA, Telephone Consumer Protection Act. And they were saying, oh, we don't have any of that equipment. And we pull out their financials where they talk about, oh, we spent $50 million upgrading to the most high tech, So it's good to look at it. You can find it there.
That's awesome.
Let's see. Gina says, State Farm did an inquiry on my husband's clue report with his ex-wife and listed him as living in a town he never lived in or received mail. And then there's a follow-up. Credit bureaus keep listing this address. LexisNexis listed as a good address, won't take it off. Help. So I'll give you my quick thoughts, Gina. As far as having a wrong address, this is the way that I do the personal or the biographical information. I think of it as being in 3 buckets. The first bucket is correct now. So my name is John Watts. That's correct. The second bucket is it's wrong, but it used to be correct. I used to live at 123 Main Street, or my name used to be this or that. And then the third bucket is it was never correct. So the credit bureaus have reported me as Watts John. That's not my name. My name is John Watts. Okay. And so if it's an address that he had never lived at, let me pull the first one back up, then I would dispute that, have him say, I never lived there. And if they don't fix it, I would look and see if there's anything else. But, we certainly will go after them for the wrong biographical information because it's wrong. And you have a right under the FCRA to dispute any information on your credit report, and they have to investigate it. And if they do a lousy investigation, they get sued. So that would be my thought. What do you think, Stephen, about this. State Farm did an inquiry. I'm assuming what Gina is saying here is that he had not applied for credit or insurance with State Farm, and they pulled his report anyway.
Yeah, and just to kind of, I guess, clarify for folks, CLUE is a form of a LexisNexis report. It's their comprehensive loss underwriting, which is kind of what insurance companies pull, but that's a LexisNexis report. So, I mean, yeah, I mean, I guess if we get a little clarification, Gina, are you saying you didn't give what they call a permissible purpose? You didn't give an authorization, for them to pull, or what? There, if you can clarify. So she says, okay. Well, I mean, so if you did not give authorization, really truly didn't, for them to pull it, then I believe that's actionable. Is that not correct, John? Could you go ahead and get her a good, smooth, quick $1,000 for that?
Well, when we sue, we always want to get more than that for our clients. But
okay, get her a $1 million. Let's go ahead and raise the bar.
Don't we need like a cat in our lap or something as we're saying that, but no, for any company to pull your credit report, and we're talking about typically a hard credit pull, either you give permission or you apply to do business with that company. So if you called State Farm and said, "Hey, State Farm, can you, quote me a policy?" Well, they would have the right to pull your credit report without necessarily getting you to verbally say, "Hey, I give you permission." Just the fact that you applied for insurance. But it sounds like in this, Gina, that he never applied for insurance, at least not recently, with State Farm. And, this may have been something like his ex-wife applied and they pulled his report. So if it is an impermissible pull, in other words, a credit pull without permission, then you can definitely sue on that. Sometimes we dispute those because, again, you can dispute any information that's incorrect and say, "Hey, this company had no right to pull my credit report, get rid of it." Normally the bureaus won't, and that's okay because you gave them a chance, and then you sue them for allowing your credit to go out, and you sue State Farm for doing this improper credit pull. So I would definitely get with somebody, Gina, start in your state, or if you don't know anybody, just reach out to me at alabamaconsumer.com and I'll try to connect you with a lawyer. But I would definitely, tell your husband to pursue that. So let's see here. We've got Amy here. She's referencing Antonio, who had the lawsuit for a couple months, no answer. Answer lawsuit, PRA, they have not responded. Call the court, nothing is happening. And then can't file a request for dismissal. So, really that depends on your court. There are a lot of courts that are not open. Now, where I practice in Alabama, our courts are open. I mean, I've been to court, I'm losing track of how many times this week. So, our courts are fully open. We're doing jury trials, everything. But there are some states where the courts are not really moving forward with anything. And then there are certain courts, even when it's open, they're sort of very slow about setting a case for trial. So as far as can you request for dismissal, it would really be if the judge is saying, "Hey, I want the plaintiff, PRA, who sued you, to do something." But you could always ask for a trial. That's typically called a motion to set trial. You say, "Hey, judge, they sued me. I answered. I'm ready to go to trial. Let's get a trial date." And that tends to get things moving. So I would at least consider that as you look at your options here. Let's see. Stephen, I lost you. Where are you? I can't see you.
That's right. Look, we put the little.
Yeah, that's right.
Let's let Shauna again from our Facebook group.
So, okay, we have looks like a great question here. Attended a training with Cindy, and I think that was with Mike Cardoza and Blaine Dixon.
Right.
So,
yep. That is. Yep.
Two lawyers. Blaine's in Tennessee and Mike is in California. We discussed refusal to pay letters. My question is, what if a dispute has been sent and returned verified? Is it then too late to send a refuse to pay requesting no further contact? And if contact is made after the letter is sent, does the original dispute give the creditor legal defense if they contact? Hope question makes sense. Yeah, it does. So let's use an example here. So let's say that I send a letter to, let's stick with portfolio saying I want debt validation. I want a copy of the contract, the statements, the purchase agreement. And they come back and say, you're not entitled to that. We've verified that you owe this debt. Okay, that's fine. Well, then I can send them a refuse to pay letter. And if they do anything after that with like very small exceptions, then that violates the law. Now, you don't have to tie it together. One strategy is you say, I want you to validate. And then when they don't, you come back with, since you did not validate, you did not give me the contract, all the monthly statements, at least from a zero balance, you did not give me the purchase agreement, I refuse to pay you. That's fine to do. You don't have to do it that way, but you can. And that sort of links the letters together. But I can tell you right now, I've got a company that I'm suing. Client sent a validation letter. They sent him, some information. Then he sent a refuse to pay. And Stephen, you'll appreciate this. They said, hey, we've already responded to you. So we deemed this dispute to be frivolous. And we're just going to send you what we sent you before. Guess what, buddy? You just violated the refuse to pay. And if you want to give your thoughts on that, I'm going to pull up that section just to show everybody.
Yeah, and so I think to kind of clarify for LaShawna, so there are actually two separate sections of the FDCPA, the cease and desist and then the initial dispute, because it sounds kind of like the way your question is asked, you're okay, if I initially dispute it, is it too late to kind of send a cease and desist if I'm reading it correctly? So 1692CC is a section of the FDCPA for the cease and desist. Look at that. My partner in crime is reading my mind. He's got it pulled up. So there's really no time limit on that. So you can send them a cease and desist at any point in time. So that's 1692CC. Then you've got 1692GB, which allows you to dispute it within the first 30 days. But not to worry, because the case laws make it crystal clear that you can dispute at any point in time, even after 30 days, and they've still got to validate it because they can't collect a debt that they can't legally collect on. So you've got 1692C and 1692GB are two separate things. So if you've disputed it first and then you send a desist, no, there's not an issue with that. They're two separate things. And I actually, I know you weren't on this, John, and what she's talking about. Some of our viewers may not have been on it. I wasn't on the call, but somebody called me today who was on Cindy's call, and she had a good question. She was like, okay, if one of the strategies is just out of the gates round one to these debt collectors, send a cease and desist. What if they cease and desist, they don't violate it? Like, if the whole strategy, and this may not be a question that you can really answer because you weren't on it, but I'm like, I kind of feel the same way. If strategy round one is to send a cease and desist, hoping they're going to violate it. What if they cease and desist? Then, are you kind of screwed because you've already told them to cease and desist? So if you continue to dispute it, are they no longer required to respond? So what's your take on that, John?
Yeah, and so let me answer that. I want to just clarify one thing. The
Sure.
1692G, this is when the collector says, hey, you have the right to dispute in 30 days. And what Stephen said is correct, that you can dispute even outside that 30-day window. Now, technically, they don't have to respond. They don't have to, quote, validate after the 30 days. As a practical matter, they do. I'm just saying, as a matter of practice, they do respond. Now, it's never a good response, but they do, because you're saying, hey, I don't owe this debt, send me proof. And if they don't, and it turns out you don't owe the debt, now they're in trouble. So just psychologically, they have to respond, but legally, they really don't have to respond. The whole thing with the cease communications or refuse to pay or the dispute letter is, you don't want to do something that is unfair to the collector. So you can't send one letter that says, validate, send me all this proof, and by the way, I refuse to pay, don't ever contact me. You can't do that. Now, you could send a dispute letter and then send a refuse to pay, or you could send a refuse to pay, and then later you could say, hey, I hereby revoke that refuse to pay. Now I want you to validate. Okay. But in terms of, as a strategy, doing a cease communications out of the gate, that's personally not something I do, unless this is like 10-year-old debt. It's not going to be sued. It's not going to be credit reported. Like, just leave me alone. Okay. But I prefer to ask them for information. And then if they don't respond, then say, hey, I refuse to pay. And I think that's probably a better strategy. We're not sending these to trick them or to, try to push them into some error. We're saying, hey, validate this debt. And if you don't get the information, then you say, look, I refuse to pay this. Or you could start off with the refuse to pay, but understand that's the purpose of a refuse to pay, is to not ever hear from them again. So if you don't hear from them, be happy with that. The last thing I'll say is, in my view, every letter should be a dispute letter. Okay, so we have a dispute letter, we have a validation letter, we have a cease communications or refuse to pay. Every letter should be a dispute. Even if you say refuse to pay, say, I dispute this debt, I dispute any debt that you have, I refuse to pay any debt, because that always triggers the idea of marking it as disputed under your credit report. And that is section 1692E8. And the other thing is, I can't tell you how many times I've been in court where there's a lawsuit filed by a collector, and this is the section here, E8. You'll see this last part, including the failure to communicate the disputed debt is disputed. But the last point I was making is that these collectors, when they sue, they'll say, well, judge, consumer never disputed this. It doesn't matter, but they make such a big deal about it. So I always want my clients, at least, to dispute that debt so that we can say, yeah, actually, I did dispute it. Here's the certified mail, here's the letter. And so, that's really the purpose of this. You dispute it, request validation, or you dispute it and say, I refuse to pay. So hopefully that's helpful.
So I do have a question for you. You said something that was interesting. You said that you can subsequently try to revoke the cease and desist, or say, I no longer. So, is that something that's generally accepted in the debt collection and legal industry? Or can they refuse to accept your rescission request of the prior? How is that just a John Wise special, or is that something that's a little bit more than just a creature of your imagination?
Well, it is somewhat of a creature of my imagination, but I've actually never seen a collector sort of refuse to accept that. And there are times where people have done a refuse to pay, then they call, and the collector says, well, wait a minute, I have your file marked as, cease communication. If you'll withdraw that, then I can talk to you. And, I've never seen a collector have a problem with that.
Interesting. Okay, cool.
So
all right, that's a good question. Good question, Lashana. Lots of good stuff there.
Yeah. And okay, so how long should I wait to file a request to dismiss? Doesn't follow up on my answer. Well, really the reason that you can request a dismissal of a collection lawsuit is for what's called failure to prosecute. Sometimes it's called want of prosecution. And there's got to be something that they're doing in violation of the judge's order. In other words, the judge might say, hey, I'm setting your case out for 2 years. So just to give you an example, Portfolio Recovery sues in Alabama. In almost all courts, we're going to trial 4 to 6 weeks after we answer. My friend Mike Cardoza in California, same lawsuit, he answers, I think he's going to trial in like 2 years. It's just different courts, different sort of schedules. So just the fact that it takes a long time doesn't mean it should be dismissed. You're really looking for something that they're refusing to do that the judge says. Like judge says, you have to send this information to the defendant, and they don't do it. And you tell them, hey, do it, and they won't do it. And you go to the judge, and you go to the judge. Well, eventually a judge may say, hey, I'm dismissing this case. But just sort of sitting there, at least in my experience around the country, that's not enough. There's got to be something more to it. And let's see, this is going to Gina on the clue. So remember, that's the one where State Farm pulled her husband's clue report. This was done a couple months ago, and the ex-wife requested it. We've disputed it, and there is more. Yeah, I would do one of two things: either dispute it again, and also reach out to State Farm and say, why did you pull? Have your husband reach out to State Farm. Why'd you pull my credit report? Or sit down with the consumer protection lawyer and say, hey, do we sue? Do we do another dispute? What do we do here? So that would definitely get my attention, Gina, if I was in your husband's situation. I think we have always had at least one lawsuit in federal court against a company for illegally pulling credit reports. So a lot of people act like that's no big deal, but it's really like, Gina, if somebody walked in and like grabbed your purse, started going through it, or going through, your computer, or looking through your phone, you're like, what are you doing? Even if they don't steal anything, it's invading your privacy. And same thing with the credit report. So we take those very seriously. And like I said, if you have any issues, finding somebody, just reach out to me at alabamaconsumer.com, and I'll be glad to help you with that. Let's see. Okay, Stephen, can you guys verbalize some type of dispute pyramid checklist highlights potentially critical areas of dispute from most effective to last resort? So data, last activity is inconsistent, late payments are inconsistent, et cetera. So yeah, I am curious what your response to that is, Stephen.
Yeah, so I guess first and foremost, I'll give the initial part of my response, which satisfies the requirements of all these attorneys. Oh, wrong way, my goodness, all the attorneys.
Yeah, like, who are you pointing to?
That's right, all the attorneys. Because, first, if you're gonna, want to set something up for the pre-litigation and go to one of these guys, you're gonna want to ensure that your client has damages, which is not very difficult. If they're declined or adversely affected or given a higher interest rate approval than what they would otherwise get, that's basically damages. Okay, so even though the FCRA per se in its language doesn't require it, 50 years of bad court cases later, the judges are pretty much going to require it. So now that being said, I think it kind of leads into the answer, because if your client, how is your client being damaged, right? Well, it usually comes down to a credit score. And how is the score calculated? Well, we never know exactly, but all the parts of the credit data affect the score. So if you've got, the last activity date, if they're different on all three bureaus, if it's not consistent, they should update it if you dispute it once, right? Like they should have they should do a recent updated date on that. Your monthly payments or your late payments and all that stuff, clearly late payments, that's negative information. That's going to have a negative impact on your score. And then, inconsistent information is definitely something that I love a lot, because although we don't have the secret sauce to the credit scores, they're supposed to be, basically what's kind of called like empirically derived, which means these credit scores are supposed to be created from like statistically sound pools of data. So if you understand these general basic concepts and you're able to argue them, and then you're able to articulate to an attorney like John, like, well, hey, here's why I believe I disputed all these pieces of data and I think it's down. Here's kind of my theory. We don't really even know how it's affecting the credit. And if he can articulate that to a judge, he's in a much better position than just telling the judge, well, the data is kind of jacked up, but I have no further reason as to why it's being sued. So I think, having a good frame up and a good understanding of how everything that's wrong on the credit can tie back to the potential damages, I think that'll allow you to really dispute just about everything and anything. Now, that being said, though, also, I think some of the judges may look more favorably to things that they tie directly to damages, because damages are financial. So like, are dollar amounts on the credit report wrong, or are dates wrong, things like that. If you can show that, like, well, this one has a credit limit of 500 and this one has a credit limit of 10,000, and we tried to get them to fix it. A judge can pretty easily identify, oh, well, I've got a credit card, I know what a credit limit is, as opposed to like a date of first delinquency or whatever other kind of field he may totally get. So, I mean, from a practical application, I think it's, those kinds of things may be easier to sell to the judge. But that's my credit repair answer, is if you could tie it back to damages and then articulate that to your attorney, I think you're going to be in a better position. Now, Mr. Attorney, what do you have to say about that one, John?
So I have a pretty simple approach when looking at credit reports. It's really just anything that's wrong. I mean, they have your name spelled wrong. They have, so I was talking to a client yesterday, and what the credit bureaus did is they took the first 3 digits of his phone number and then put that as an area code on some different number. And, he's like, hey, I never had those phone numbers. Well, let's dispute them. Okay. And the reason this is important, let me just pull this up. So you see kind of what I've highlighted over here is if the completeness or accuracy of any item is disputed by a consumer. Well, any item where? Any item of information contained in a consumer's file. Well, that would include your name, your date of birth, your social, your phone numbers, all that sort of stuff. So that's really my simple test is it wrong? Okay. And so if I'm looking at Capital One and Equifax for June 2018 says 30 days late, Experian says 60, TransUnion says no data, well, I'm going to dispute that because remember it says the completeness. Well, TransUnion doesn't have any data, so that's incomplete. The accuracy, well, is it 30 or is it 60? It can't be both. It's got to be one of them. So I don't really prioritize it. It's just I want to identify every single error. And this is where I differ from sort of self-proclaimed credit repair gurus that are, out there who go, oh, only dispute, 5 items or 2 pieces of information per item. That's just complete garbage. Dispute everything. Because if you do a letter, and let's say there are 10 mistakes on your biographical information, and then you find 5 accounts that have 5 errors on each. Well, if my math is right, Stephen, you're the accounting guy. I think that's 35 errors. Well, let's say they fix it plus the 10. So you got to
that's why
carry the 1 and,
I'm just the credit guy. I'm not the math guy. Credit's not supposed to add up.
So let's say there's 35 errors that you dispute and they fix 25 of them. There's still 10 that are not fixed. Well, see, if they go, oh, well, Judge, that was just a mistake. Oh, and that other one was just a mistake. Oh, we just sort of dropped the ball there. Oh, well, that other one, well, And I mean, this is the argument we get, Stephen, is they say, well, your letter was kind of long. And we stopped reading it after page 3. Well, that's on you, buddy.
I mean, your credit report's kind of long, man. What are you talking about?
Yeah. I mean, try that with the IRS. I help people that are, have 50,000, 100,000 owed to the IRS. You say, well, it was a 4-page letter and I could only find time to read the first 2 pages. So I couldn't have known that I owe 100,000. No, the IRS doesn't buy that. And so we don't buy that either. And so dispute everything because first of all, you have a right to an accurate credit report. And second of all, you give them the chance. That's exactly what's on the screen. You give the Bureau a chance to fix it. If they choose not to fix it, man, they deserve to be hammered. And the more violations you can find, the more likely it is that it rises to a level of intentional or recklessness. And then we start talking about punitive damages, which as lawyers, we love punitive damages. So that's, and look, nobody sitting on a jury is going to say, wow, I just love the credit bureaus. They're just so nice and responsive and, you write them a letter and it's not like they send you just meaningless form. No, everybody hates the credit bureaus. And so, give them a chance to fix it or to dig themselves deep in a hole. So that's my response to that. Let's see here. Going back to Gina, ex-wife, did the pull with State Farm, told them repeatedly it was fraud, being stonewalled, disputed and complained. Yeah. So again, Gina, I would just, get with the lawyer, get with me. I'll help you find somebody. there's nothing like suing these bad guys to get them moving. They suddenly will, you're not stuck in some cubicle somewhere. Now it goes to the top, and man, they can get stuff done when they get sued.
Unless they get stuck for 2 years in court, like we were talking earlier, once you sue them.
Yeah, yeah. So here's Stephanie that refused to pay, and Cece is sexy. Oh, which speaking of this, so here we go. You notice the resemblance here. This is Stephanie. And let me just copy her YouTube channel.
Look at that. I can just tell that Stephanie is blushing right now because even though she's got the YouTube page and she's a public figure superstar, she gets a little embarrassed when we help her promote herself. So everybody go to SOS Solutions on YouTube and
that's right.
Love Stephanie and tell her how awesome and amazing she is, because she really is.
Yeah, she's got, people like Metro 2. She's got some Metro 2 stuff in here, and easily remove names and addresses from Experian. And so, yeah, she's got some good stuff there. So check out her channel. And let's see here. So, Draper, does a dispute over the phone count? Because I've been disputing for 6 months now. I gave them the police report record of number filing, police report, a wallet being stolen, cards being used. So I'm assuming, you're talking about you've made a dispute over the phone to the credit bureaus. And if that's the case, yes, that counts. We can do it by letter. We can do it by phone. Matter of fact, I think it's SageStream, Stephen, that they give you the address if you want to like walk into their office and make a dispute.
You can actually walk into any one of them's office, any one of them. So I don't think that was proper English. You guys, all y'all know what I'm trying to say. Well, there we go. Pull out the Southern drawl. But you can, walk up and go in there and dispute it. Because actually, John, doesn't the FCRA have provisions for like if you're disabled and stuff, you can actually bring one person with you and to help you with your dispute if you walk in?
Yeah, I think so. And so, any way you do it, if you can, you want to document those phone calls. So if when you call, they say, please be advised, all calls may be recorded, then I would record it. The simple way is you take your cell phone, speakerphone, and then you take an iPad, a laptop, open up a voice recorder, just record it. It's the easy way to do it. And because they will accidentally lose the records of those calls if you sue and they know you have no proof. So now they would be very offended by that, but that's my view of the credit bureaus, that they will lie with, it won't affect their conscience at all.
Just don't pull up like right to their front door in like a big U-Haul, because that may spook them a little bit.
Yeah, you might be talking to
discretion. Don't go Timothy McVeigh style on these people, right?
So here we have. Well, they must be talking about you, Stephen. So that's.
Yep, that's LaShawna again. Of course, we love you as well. Yep.
So let's see. Helped me out 6 months ago. Well, you're very welcome, Jimmy. Thank you for saying that. Let's see. Gina, this is back to the State Farm pulling the clue report. Did through NAIC last time, rural Tennessee. Actually, Gina, we are waiting for it. Yeah. So Gina, get with me and we'll talk with Blaine Dixon. Blaine is in, it's Nashville, but I think it's Clarksville, but it doesn't matter. He can help you anywhere in Tennessee. But feel free to, you can reach out to him, reach out to me, and Blaine and I do some work together on cases. And let's see here. Danny says, why would Credit Karma and TransUnion show derogatory account status when I reaffirmed an auto loan that was never late and paid it off? That is a great question. So, Danny, I'm assuming you filed bankruptcy, probably Chapter 7, and then you reaffirm that loan. And when I say reaffirmed, I mean like legitimately reaffirmed it. So whatever your judge requires in bankruptcy court for it to officially be reaffirmed, then my view is that there really shouldn't be any derogatory status if you were never late, you paid it off. I'm curious, Stephen, if you know off the top of your head from Metro 2, it wouldn't be, discharged in bankruptcy because it was reaffirmed, which takes it out of a discharge. So should there be anything derogatory, assuming we were never late, paid it on time, we paid it off, we just went through a bankruptcy and reaffirmed it, should that have anything negative?
Yeah, I mean, that would be one of the account condition status codes, and it would probably say something like in bankruptcy, or was in bankruptcy, reaffirmed. And so that would basically, the bureaus would consider that to have an adverse trait to it, because it is a condition that's related to a bankruptcy. And so that's probably where, now, I mean, first, I guess I would say Credit Karma and all these monitorings aren't really very good. Judges of what's actually the truth. So you want to take a look at what's on the actual real reports directly from the bureaus and see what the real status codes are. But Credit Karma probably has a trigger that if they see the word bankruptcy, they're going to mark it in their software as negative. And so that status code would be something like, was in bankruptcy but reaffirmed, probably. So that's probably how that's happening.
Yeah, and the most important thing from that is I have Stephen now saying your real reports, which he always made fun of me for saying that before. But yeah, you definitely want to look at your actual reports from the bureaus. These things like Smart Credit and other stuff, they're fine, Credit Karma, but they're not your real reports. And so you want to go directly to the information. Stephen, we won't spend much time on this, but I just pulled up Metro 2 and just did a search for reaffirmed. And bankruptcy was filed, discharge dismissed, the debt was reaffirmed. And so it gets into some technical details on when we reaffirm stuff. And, here we go. This is the FAQs. How should an account that's been included in bankruptcy be reported? Consumers making payments, even though the account's not been reaffirmed. Preferred method when they're completely or partially reaffirmed. So maybe, Stephen, since you are the master of all Metro 2 matters, for our next time, we can have a little something prepared and go through that, because it's a good question. And Danny, maybe you could also let us know from your actual reports, which just go to, I'll put in the chat here. Just go to annualcreditreport.com and tell us what your actual reports are saying. Are they reporting this as negative? TransUnion will first have your negative accounts and then your positive. And let's see what it actually shows here. Let's see.
Not the FACO reports, but the actual report.
Yeah, the real report. So Gina, okay, very good, Gina. So yeah, look forward to that. Danny says in bankruptcy. Okay, this is a good question here. How often can a bank check your credit if you have a card with them? And so, Stephen, we're typically going to be talking about soft pulls, not hard pulls. They won't affect your score, but these will be called like account reviews and things of that nature. How often can they do that?
Yeah, well, I don't think there's a limit to that, because it is what's considered, because the FCRA doesn't say soft pull, but it's considered a soft pull in that it doesn't affect your score. And they do have under 1681B, that's where your permissible purposes are. They do have the ability to pull it for, if you have a legitimate business relationship, for an account review, something like that. I don't believe that. I don't believe is that, in fact, the FCRA doesn't say that they can only pull it X number of times in a period of time. It doesn't say that. So, John, my answer, and I'm not going to use a lifeline on this one because we may get some tougher questions, but my answer is that, as long as it's within reason, they can, and as long as they can justify it for a legitimate account review, I don't think that there's any limit to it.
Yeah, there's no limit to it. And the only time this becomes a problem for these guys is, like, let's say you paid it off, closed the account. Let's say you discharged it in bankruptcy, and now there's no longer a business relation, and they keep pulling your report. That's a problem. But if I have a Discover card, frankly, they could pull it every day. They could pull my report every day. And because I have that ongoing business relationship.
Sometimes it seems like they do pull them almost every day when you look at these reports.
That's right. That's right.
Like, what's this John guy up to? We want to make sure he's not becoming a high risk,
Yeah, that's why my Equifax report's like 100 pages long, because it's all those soft pulls.
He hasn't sued us in a while, and so I'm not sure if he's still making the income. He may be on the verge of charging off our account. We need to check on him.
That's right. That's right. So let's see, helping consumers. Well, hey, that's what we're here for on this show, and we love the questions. Let's see, Mary Jane Lucas says, go after names, dates, employments, address, cell numbers, demand the credit bureaus correct them. Yeah, absolutely. I mean, it should be your accurate information is on there. Now, again, if your name has changed, that's fine to be on there if it was correct. Sort of my rule is, if we're talking about addresses, if I moved 6 months ago, I'm not going to demand they take off that address. I basically go with 2 years. But as a phone number that I no longer have, there's really no reason to have that on there. And same thing really with employers. And the thing is that what I like about doing the biographical stuff is sort of get you some momentum. You're going through your report, and you're like, oh, I find this error and that error and this one and this one, this one. And it gets you some momentum going, and then you hit those accounts. And now, you're feeling good, and man, I'm finding these errors, and it's motivating for most people to do it that way. Let's see, and here is Stephanie, SOS. So definitely check her out. Let's see, also school loans, duplicate accounts, have the credit bureaus correct them, keep your letter one page, dispute. Yeah, so the difference I would have, Mary, is I don't care how long the dispute letter is. I mean, I've had dispute letters that are many, many pages long with, 40 pages of attachments. And it's sort of like, I'll tell you this on, since we're talking about YouTube, I do a lot of videos on YouTube, and sort of the legal marketing experts will say, never have a video more than 90 seconds. And, my most popular videos are like 2 hours, 60 minutes, 45 minutes. And so it's like anything, it needs to be as long as it needs to be, but no longer, and I mean, don't artificially make your letter, super short if you need more information. Because I'll get people that send me their dispute letters, and I'm like, well, you didn't identify all the errors. They said, well, I was trying to keep it to one page. I'm like, use more pages. It doesn't matter. Now, I do think it's right about simple jargon. I mean, there's no magic language you have to use. Just, hey, this is wrong. Equifax says my high balance is 4,000, Experian says 3,000. How can it be both? Please fix this or delete the account. So just normal English works great. And that I think is the best way to do this.
It's kind of like, what's the best way to kill a weed? Like Mary Jane would take the little bottle of Roundup and just squirt it right on the roots and be done with it. John Watts would get the crop duster and just napalm the entire block. So, I mean, it's going to get the job done at the end of the day. There are just a few more opportunities for further casualties with.
Well, and also from my standpoint, when I'm helping consumers do this, it's with a very simple goal. Either delete the incorrect information, fix the incorrect information, or if the credit bureaus choose option number 3, they get sued. That's our approach. So we're not into doing rounds and rounds of disputes. One good dispute, maybe there's a reason sometimes to do a second one, but it's basically, I tell clients, say, look, we're going to do this dispute. It's going to get fixed, deleted, or we're going to sue. And then when we sue, it gets deleted. They pay you money and pay me money. So, we're all pretty happy about it. Let's see. Do you guys help people in Miami, Florida? So I'm not licensed in Florida. We do have some lawyers we know. Aaron Swift is in Tampa, and he's a good guy. And most of the lawyers that do this type of work, we're not sort of limited to local areas. It's not like doing divorces where you don't stray out of your county. I mean, this stuff ends up in federal court, and I mean, I've lawyers that get me involved in cases all over. So you just need a lawyer that understands this type of work. If we're talking about credit reports, now if you've been sued by a debt collector, it makes a little more sense to get somebody local to you. But I'll just tell you, I represent people who are sued by debt collectors even when they're 6 hours away, and so it doesn't matter to me where they are in my state, which is Alabama.
We do have a mutual friend in Miami, Angel Uvet. He actually
Okay.
does, and so I guess Kareem, basically reach out to John if it's something that he can do. Cool. If not, between him and I, we do know somebody that is actually in Miami. If you need somebody there, for sure.
Yeah, and I'll put the link to go to the contact on my my website. Let's see, Dia Draper, not the credit report, to the credit card company. Oh, okay, so you call the credit card company. So you really need to do that in writing, in my view. You need to tell them, hey, wallet was stolen, give them the police report, maybe an affidavit, what's sometimes called an identity theft affidavit. And you just want to document that because there are some protections under the Fair Credit Billing Act that really only get invoked if you dispute in writing. So that's what I would do there. Let's see. Stephen, we'll let you take this one from Mary Jane Lucas. How do you challenge a verified account from the credit bureau? Do you challenge the method of verification? And maybe if you want to first explain what that means, method of verification.
Yeah, sure. So the method of verification itself isn't a dispute, but it's part of the 1681I dispute section of the FCRA. So, basically, if you send in a dispute, really disputing any of the information, like Matt or like John showed earlier, if they don't fix it, they don't correct it, you do have the right to basically ask what you call the method of verification, which is really asking them for a description of the reinvestigation procedures. That's really what the FCRA entitles the consumer to request. So, you can write to them and say, dear bureaus, now, here's how you can use it. So that method of verification, i.e., the request for description of reinvestigation procedures. So if you send a dispute, you get the results, it's still jacked up. You can then send a follow-up letter and say, hey, please give me a description of your reinvestigation procedures. I'm just thoroughly confused because I live confused because you guys can fix this stuff. I asked for X, Y, Z. None of that stuff was done, so please give me a description of the reinvestigation procedures. And what's going to happen is they're just going to give you a little form letter template. It's just going to be a template with like 3 sentences that says, when we get your dispute, we have a process to forward all reasonable information to the furnisher, and we wait for them to respond, and we update your credit report, and we love you. And that's what you're going to get back. Okay, so, but that can be another cause of action that somebody like John can throw into a lawsuit if he wanted to. if you send them a request for the description of reinvestigation procedures, that's an actionable section of the FCRA. So if they, so I wouldn't just basically say, please give me your method of verification. I would kind of tie it, at least somehow logically, to the issues of the dispute. Dear bureaus, I'm confused because my first dispute was very well articulated, spelled out very specifically the data that was wrong. That information is still wrong, best I can tell. So therefore, please give me a description of the reinvestigation procedures and send that over to me. They're going to send their form letter, which in no way, describes the reinvestigation procedure, or if it does describe it, it would demonstrate that they were unreasonable because they completely ignored everything. That would be another cause of action, another claim that somebody like John could put into the lawsuit. But they're kind of two separate things. So you've got, the dispute, and then you've got the right to ask for the description. Both of those are actionable, but just understand the method of verification isn't in itself a dispute per se.
Yeah, and the other thing I would say is either the information you're disputing is inaccurate or it's accurate. And despite what the FCRA says, the judges do not let you say, well, hey, I demand that all this be verified, and if you can't verify it, then delete it. The judge, the very first thing in a lawsuit is going to say, number one, was the information accurate or inaccurate? If you say, well, it was accurate, but they didn't do it good, you're out. You're thrown out of court. Okay. So we really should be disputing things that are actually wrong, that are inaccurate. And then if they verify it, the way that we, quote, challenge it is we sue the credit bureaus and we sue the furnisher. And, that has an amazing psychological effect on them to make them want to get that off of your report and to open up their checkbook, which is always nice. So what Stephen was saying about the method of verification, I think that's very good. Like, let's just imagine you say, you have the date of last payment as June, you have the account was closed in April, and you have me late in September. Like, none of this makes sense. And they just verify it. Well, your method of verification, you could sort of re-emphasize that, say, look, guys, like, how in the world did you verify, when the late payment's here or the last payment's here and the close date's here and this and that, and spell it out. So when you get that goofy little form letter that Stephen's talking about, and then that goes in a lawsuit, the judge is like, look, this is a very sensible letter that she wrote. Why did you guys respond with a nonsensical form letter? Well, that's what we do, Judge. We're nonsensical form letter type companies. That's how we roll. So that's really the way to do it. Stephen, I see it's about 5. I can actually stick around a little bit longer if you can, and we'll try to
Sure.
knock out these questions here. So very good, Mary Jane. Let's see. Danny says, what can a collector not say on a voicemail? So basically it would be, you can't threaten people with something that either is illegal or that you would not do. You can't say, if you don't pay this, we're going to arrest you or deport you or something like that. They can't say, we're going to garnish your wages unless they've already sued you and have a judgment. If it's something where a third party, that's anybody other than you or your spouse, can hear it, and a third party does hear it, and they start talking about, like, imagine I'm a collector, I leave a message for Stephen on his voicemail, and as I'm leaving the message, it's playing out loud on sort of an old-fashioned answering machine, and his brother is there listening to it. Well, I just violated the law. I mean, I can't tell you how many of those lawsuits I filed. And so they really have to be careful. They have to identify themselves as a debt collector, but then if a third party hears that, that's a problem for them. And so they went whining to the courts about this, and the 11th Circuit Court of Appeals, which is Alabama, Georgia, Florida, basically said, you guys pretend like you're in this no-win situation. Here's a thought for you. Don't leave voicemails. How about that? And so, just in terms of what they can't say, they just can't threaten, they can't lie, they can't do anything that would be unfair. And they have to be really careful about a third party overhearing it. Here's one for you, Stephen. Can bankruptcy be removed from a credit report? Or are these services that claim they can legit? So what we're talking about is, I filed bankruptcy 2 years ago. Stephen, can I pay you $1,000 and you've got the magic formula to remove the bankruptcy from my credit report? What do you say to that?
Well, yeah, I mean, so certainly, like John had said earlier, any item of information, including a public record bankruptcy, can be disputed. And if they can't validate it, verify it, fix it, they're supposed to delete it. That's true. I mean, nobody really legally and lawfully has some sort of a silver bullet magic trick on these things. So, I mean, I would be leery, especially if they're trying to charge you up front, that violates the Credit Repair Organizations Act. But yes, they can be challenged, and it is possible for them to be removed. but it's a battle just like with anything else that's on your credit report.
Yeah, and what I would say is you need to find an error. So I filed a Chapter 7 3 years ago, and they say it's a Chapter 13. That's an error. I can dispute that. They say I filed in the Central District of California, and really I filed in the Southern District of Florida. That's an error. They have the wrong case number. They have the wrong date filed, the wrong date discharged. You just look for any error. And look, certainly don't pay somebody to do this. Okay. I mean, I can tell you what sort of the trick is. It's based on a lot of false assumptions, but the idea is you dispute it, and they say, "Hey, we verified this with LexisNexis," and then you go freeze your LexisNexis report, you freeze your SageStream report, you write a letter to the bankruptcy clerk. Hey, do you guys verify stuff to the credit bureaus? They write you back, say, "Nope, we don't report this. We don't verify anything." You send all that to the bureaus and say, see, you can't get it from LexisNexis and you can't get it from the clerk. And they come back and verify it. And then you want to sue. And the judge starts with the very simple first question: is it wrong or is it right? And you go, but the verification and the letter from the clerk and the LexisNexis. And the judge is like, case dismissed, get out of here. So it all comes down to accuracy. Now,
the problem is the judge, not the facts. That's what I'm hearing from John. If we didn't have these stupid judges that would not read the law, that would read the law as it's written, then you'd be perfectly fine, Mr. Heyman. But unfortunately, they want to know if it's accurate, not if their verification procedures failed, which is totally actionable the way Congress wrote the law, but not the way that these bad precedents have twisted the law.
Yeah, and this is not to go off on a long tangent, but this is important. When you file a lawsuit and you're in front of what's called a district court federal judge, that judge is bound to follow what the appellate court says. So a district court judge in Alabama, Georgia, Florida has to do what the 11th Circuit says. Basically, every appellate court has said it must be inaccurate to sue. So these judges have to follow that. Now, they may say, well, I think the law actually reads a little different. They don't have any power. They have to follow the way the higher court says. And look, I know I'll get messages from, well, my cousin did this, the letter to the clerk and it worked. Well, you can send it on pink paper with little, rainbows on it and it can work. That doesn't mean that is like the silver bullet, the secret thing. I would rather see people spend time on finding actual inaccuracies. And then the last thing is just, if you're applying for a loan, they know you filed a bankruptcy, even though it's not on your credit report. If you're doing a mortgage, they're going to search. And so it's kind of I think people spend a lot of money, a lot of effort, and it doesn't really do a whole lot when you could very simply, you have your bankruptcy file and you have your credit report and you go, are there any differences? Dispute it. So that's what I would do. Let's see. How do you remove closed accounts from your credit report? I'm going to answer that, Stephen, say the exact same way. You find errors and you dispute the errors and it gets fixed, deleted, or you sue and they delete it and pay you money. So that's the answer. Let's see here. Miss Michelle. LVMV never responded to my debt validation letter, sent the debt to another company to collect. What should I do after resending another validation letter? Well, I would send it to the new company. Definitely do that. And the thing with debt validation, so if you send it within that 30-day period of 1692G, the debt collector has basically three choices: validate the debt, do nothing. They don't have to respond to you. People think there's a 30-day time limit to respond. There is no time limit. They can respond, they can do nothing, or they can get rid of the debt. And then the next collector that gets it, you have to send them a validation letter. So it's sort of whack-a-mole in a way. And do you have any thoughts on that, Steve?
Well, just to clarify, so if they do nothing, so like what John's saying is if you send that initial dispute, which you have 30 days to send it to them, it said that they're just supposed to cease collection until they verify it. So if they do nothing, they are supposed to cease collection. It doesn't mean that they're supposed to remove it off the report. They are supposed to notate it as in dispute, though. So if they don't put it as in dispute and they continue to collect and they haven't responded, then you've got some issues there. But no, I think you've covered it pretty good on that.
Let's see. So we have Windy City Transplant. So glad to see the live discussion. Well, we are glad that you're here, and thank you for saying that. Let's see, Amy, should I be able to dispute incorrect names on my credit report via online? You should be able to. I'm not a big fan of online disputes. I like certified mail letters, but you should be able to dispute that. I want to say, Stephen, is it Experian that maybe gives you a hard time on addresses if it's tied to an account?
Yeah, if you go online, the Experian portal, they won't even let you dispute it if it's tied to an open account. Now, if you go to the TransUnion portal and you only dispute personal information on the online dispute, like in other words, if you don't include any trade lines with it, pretty much the results instantly, which is kind of cool. And you usually do get a lot of deletions of personal information. So, and then Equifax, they'll usually send you the response within a few days. Experian will give you the response within a few days, but they won't even accept the dispute request under some certain circumstances, like if the address is attached to an open account or something like that. So when you do it online, they each kind of have their own quirky little technological quirks that you can kind of figure out how to work to your advantage or disadvantage in Experian's case. They won't even let you dispute it.
Yeah. So let's see here. Recently, I had a third-party creditor sue me on an old debt, old overdrawn bank account, wasn't aware of, 10 years old, past statute of limitation, court dates in June. How can I win? Well, if they filed the suit after the time period to sue, the statute of limitation, you raise that as a defense and you prove that. That's your burden to prove that. I'm not sure exactly when they sued you. Sometimes they sue us and then they may take them 3 years to get us served. And so we go by the date that the suit was filed, not when we were served or when the trial date is. So I would definitely get with a consumer lawyer in your state just to find out your options. Can you win this on your own? Should you hire a lawyer? Should you settle it? What should you do? I would be careful about talking to a bankruptcy lawyer because, to a man holding a hammer, everything is a nail. And so, but if you can find somebody that actually defends these cases, and then they can tell you, yeah, you can be defended or you can do it yourself, or no, you need to go to a bankruptcy lawyer. So that would be my thoughts. And let's see, Mary Jane, thank you. You're very welcome, Mary Jane. And let's see, going back to that suit, 6 years. So yeah, if you defaulted 10 years ago and they sued you, more than 6 years after that, then that's a problem for them. So here's one for you, Stephen Ezra. Do you use UCC? And I'm assuming we're talking about in the context of an auto type loan or some other sort of goods that have been sold that would be covered by the UCC.
Yeah, so I'm not really sure, Ezra, if you want to clarify, because different people have, when they ask that, they mean different things. I mean, so there is a provision of the UCC that allows you to request a statement of your account from certain types of secured parties like auto loans. So it's a totally legitimate way. They're supposed to respond within 14 days for you to be able to get records and stuff from an auto loan lender. But other people that ask about the UCC, they're kind of talking about like is the debt valid and sovereign citizens and all this other kind of stuff, which none of that other kind of stuff that I do. Basically, but I will use the UCC request to get the statement of account sometimes from an auto lender. It's a good way to get documents, but as far as the actual real disputes, that's where Metro 2 comes in, because that's their industry standard for the accuracy, and that's really kind of the main hammer that I use on them.
Yeah, and let me just show for people what Metro 2 is. We call it Metro 2. It's, the official name is a credit reporting resource guide. And this is put out by the Consumer Data Industry Association, CDIA. It's basically the three big credit bureaus and Innovis sort of have this trade group, and they come up with this. And Stephen, didn't Matt Listro isn't he having somebody come from CDIA to Credit Con?
I believe, yeah. So Creighton Francis is the CEO of the CDIA, which is the Bureau's Trade Association, which is so the manual is called the Reporting Resource Guide, but the industry standard, the data format which this describes is called Metro 2. So that's the name of the guide, but the industry standard format is called Metro 2. But yeah, I believe he's having Creighton, the CEO of the CDIA, attending a CreditCon this year.
Yeah, so that would be pretty good. I'll just pull that up real quick. See if we can. So look at that guy.
Look at that sponsor right there. Look at that guy, man.
Let's see here. Speakers. Yeah. Okay. So yeah, President, CEO of CDIA. So this is a presentation I am just personally very interested in, Stephen, because I mean, look, these guys are, I mean, this is the credit bureaus. Okay. So they see certain lawsuits, and at least from our view, they then change the manual to sort of justify it. But I will say this, I mean, I think that there's some of that going on, but they also are truly trying to get to accuracy and coming up with these standards to help the industry. So I'm very, very curious to hear from Francis about that.
Well, I mean, I agree. I mean, the standard is pretty solid. It's just the fact that the bureaus in no way on any of the consumer-facing reports that they give you conform to their own standard. That's really where the breakdown is. And I mean, you look at the paper reports or the annual credit reports from all three bureaus, and they all look different, and they tell you different things, and they're missing fields. I mean, so the industry standard itself, I would agree. It's a pretty robust standard. But unfortunately, the bureaus, well, no, fortunately, actually, for us, the bureaus just kind of, they're just so big, and I don't even have any idea why they don't give you full reports that are accurate. But we use that to our advantage, don't we, John?
That's right. And I'll just point out, if anybody is going, John Olsheimer, now he's always on the other side of, consumer lawsuits. He's an expert witness for the bureaus. He's a good guy. He knows what he's talking about. Let's see here. Look at that.
Look at that guy, huh?
Security is really following that Credit Con. This guy is going to be there.
Dude,
that's a little disturbing.
Security was falling when they had the CDIA president, and then Matt was like, I got to make it up. I need the most premier speaker. Hey, Stephen.
All right, we're going to have to shut this thing down. All right, let's see here. Crystal, do you work people from North Carolina? To some extent, Crystal, sometimes I'm talking about my firm, can help people from other states depending on where a lawsuit's going to be filed, or we may work with a lawyer. So just reach out to me at alabamaconsumer.com and be glad to either help you directly or say, hey, here's a lawyer to talk to. Ezra has something similar in Florida. We mentioned a couple of guys. What's Angel's last name in Miami?
Luvet, Luvet.
Okay. And then Aaron Swift in the Tampa Bay area is a good guy. Let's see, here's Gina. This is back on that. Let's see, told by a collector that NCTUE was not a legitimate credit bureau because on Big Three, it's collection agency, DirecTV listed. So I'm a little unclear on that. What are your thoughts about that, Steve?
Yeah, NCTUE, I forget what it stands for, but that's one of these other specialty bureaus, is what she's saying. And yeah, it's a legitimate bureau. I mean, there's hundreds and hundreds, there's actually thousands of bureaus when you look at background screening, apartments, and all these things. And so they're definitely, I mean, if they're reporting information that's covered under the FCRA, they're going to be a credit bureau. So now, what I see here is that a debt collector gave you false or misleading information. And so, I'd be curious as to why a debt collector is telling you that they're not a legitimate credit bureau. If it is a legitimate credit bureau, then they give you a false or misleading statement, which puts the debt collector in violation of the FDCPA potentially. Is that debt collector the one that's reporting to NCTUE or not? In which case, then I'm just curious how that conversation came about. But But yeah, they would be. I mean, I'm not totally familiar with NCTUE, but there's hundreds and thousands of bureaus. So
Yeah, and this thing, it's from the CFPB, and
there
you've
it is.
got
Go up. Yeah, nationwide. Oh, never mind.
yeah,
Yeah.
the nationwide ones are, sort of the big ones we always talk about. But I mean, the way I describe it to people is there's a credit bureau, has nothing to do with whether you pay your debts on time. It's for truck drivers and whether they backed into a pole or whether they've been in an accident. And so there are just countless credit bureaus. So yeah, Gina, I would just try to give us a little bit more information about exactly what happened, because here's the simple thing. If a debt collector lies to you while collecting a debt, they need to be sued. Okay, so
Yeah.
if they go, hey, you can't file bankruptcy because it's Thursday, well, you sue them for that, or you're not allowed to file an answer in a collection lawsuit. That's a lie. We sue them for that. So when they lie, we sue. That's the bottom line.
And I just pulled it up. It stands for National Consumer Telecom and Utilities Exchange. And so they're a consumer reporting agency.
And here's the other thing that maybe this will help. And this goes back to that bankruptcy removal. LexisNexis is a credit bureau, and LexisNexis is a vendor for other credit bureaus. And so people sort of just assume that's all one and the same. You might tell LexisNexis, look, I want a security freeze, blah, blah, blah. And they do it, but that doesn't affect their ability as a vendor to go check out public records like a bankruptcy. So this NCTUE, I don't know, maybe they're also a collector. I don't know. I just haven't dealt with
They're
them.
one of those specialty credit bureaus for telecom and utilities.
Yeah, but what I'm saying is they may also have another role or another sort of hat that they wear. And let's see. So, well, you're very welcome. And let's see. Windy City Transplant. Well, you are very kind. Also, check out Stephanie's channel. She has a lot of good information on there. And let's see here. I think. Go through his videos. Crystal whipped a major foreclosure firm. Well, hey, we always like to see foreclosure firms get a hit. So thank you, Alonda. Let's see. No direct TV and IC Systems. Yeah, so IC Systems is a private collector up in Minneapolis. And so I think, Gina, if I remember right, you're in Tennessee, if I'm remembering that correct. And either get with me or get with Blaine Dixon and just sort of, talk about all of this. Let's see here. I've requested validation from Altran, received some statements, which I'm not sure the actual validation letter. So it's a great question. The issue is that, unfortunately, most judges say they don't really have to give you much for validation. So we ask, personally, I ask for the contract that set up the credit card or the medical bill. And then I want all the statements from a zero balance to whatever the charge-off amount is, so I can see those. And if a debt collector says they bought the debt, I want to see that purchase agreement. They're not going to send you all that, okay? But that's okay, because if what you get doesn't satisfy you, that's where you may come in with a, hey, you didn't give me the contract, the purchase agreement, all the statements, so therefore I refuse to pay you. And sometimes when you send that, then they send you more information, and then you sue them for that. It's like you had your chance to send me information, you chose not to. So let's see. Okay, well, I think that is about it. And so Gina, well, thank you. At least Steven's awesome. And so, I just try to not get left behind by Steven here. So
We're both. It's a team effort of awesomeness. Of awesomeness.
Yeah. See, we're 0.6 of a good person. So if you put us together, we are 1.2. So, just depends on how you scale us here. But well, listen, guys, we will wrap this up, and let's see, we'll be back, I guess, in a couple of weeks.
2
Steven.
weeks. Yeah.
That'll be that's gonna be right after CreditCon, won't it? I guess
It will be. Yeah. We'll be fresh. I'll be fresh back from the airplane.
Yeah. So Stephen may be wearing one of his shirts. He's got this like swag that he's, created, and I'm sure selling for some outrageous price, probably.
It's not outrageous. You know what? Because if you don't see value in it, you're not going to buy it. So then there's no transaction. So
Okay.
you see value, will you buy it? And then it's not an outrageous price. It's a remarkable. StephenPalmieri.com. I've got some swag. I've got some shirts. That's what John is trying to say. Get your pre-lit swag over there.
Yeah. Let's see here if we can pull this up. What do we got here?
You got the little store up there and little shop now. So we've got pre-lit, all sorts of good stuff on there. Baseball caps, shirts.
Shop now.
Yeah.
So we got the book you wrote. You've got a computer for $99. That's awesome.
That's the training course, which John
the training course.
Part of. Yeah. Let's see. He's
right.
got pre-lit. Oh yeah, Stephen Palmieri caps, pre-lit caps, everything you need in your life.
So I'm lit, you're lit, we're lit, pre-lit. Very good.
That's right. That's
some
signature.
of the other ones I may have to edit here, depending on the language content. But what do we got here? Coaching. Who do you coach? You coach
anybody who wants it. Let's
Okay.
talk. John, you could use some coaching. Let's talk, man.
Yeah, I sure could. All right. Well, hey, let's put this.
Yeah, we do have the training course. Go to creditrepairtrainingcourse.com, $99 a month, 30-day free trial. We talk about Metro 2, industry standards, powers of attorney, everything that you're not going to find. Credit repair training course. Yep. And come check it out. We've got lots of content. At least come check it out for the free trial period. You'll get more information and you'll know what to do with.
All right. There we go. And what is the let's see. So this is the private group. And
that's
then
the training course group.
The community group, it would just be credit repair, pre-lit, disputes, training, community. Is that right?
Disputes community group. Yeah.
Disputes community group. Okay. Just reach out to Stephen. He'll get you to the right place. And,
that's right.
Well, hey guys, hope you guys have a wonderful rest of the week, and we'll see you in a couple of weeks.
All right. You guys take care.